Hello and welcome again to Immigration News and Views. My name is David Nachman and I'm one of the managing attorneys at the NPZ Law Group. That's Nachman, Pawani, Zimochek Law Group. We have offices located in Ridgewood, New Jersey. We also have an office located in Midtown Manhattan. We also have an office in Indianapolis, Indiana. And we have a presence in Boston and also in Chicago for the convenience of our clients. So today I want to talk to you a little bit about what's called the request for evidence. And I believe we've done some other videos. You may be able to find some other videos on our blog site about the request for evidence. But specifically it's timely because now that the H-1B non-immigrant visas have been submitted for the April 1st filing date, the cap date, the government has now run its lottery and it has chosen the H-1B non-immigrant visas that will be subject to the cap, which are the 65,000 that we've talked about, which are bachelor's or its U.S. equivalent, or the 20,000 masters. So now what happens is that the government will institute premium processing, and obviously they've delayed the premium processing date. For those of you who have filed for premium processing, you're aware that the premium processing date was delayed and has been for several years because the government, of course, is trying to deal with the volume of H-1Bs that are submitted, of course, all within that first week in April. And so now what they're going to do is they're probably going to be issuing some approval notices. The approval notices will come out immediately. Obviously, if you're premium processing, those cases will come electronically. But for many of the cases that were submitted, clients and individuals who submitted H-1Bs will be receiving what's called the RFE, the request for evidence. And just so that everyone realizes, it is not an uncommon thing to get an RFE. In fact, I would even go so far as to say statistically almost 30% of the H-1B non-immigrant work visas that are submitted do beget RFEs, requests for evidence. So we get many questions from individuals who get RFEs seeking a second opinion about their attorneys having submitted the H-1Bs as to whether or not something wrong may have been done, which is the reason why the RFE came. And what I want to do is I want to just explain that it's usually not because something wrong was done. I mean, obviously there could have been some type of a deficiency on the initial filing of the H-1B, and obviously the quality of the package that's put in is usually helps to determine whether or not you're going to get a request for evidence. Obviously in our office we strive to answer every single question in advance, and we have a tremendous number of years of experience having dealt with RFEs, requests for evidence, so that we're able to sort of preempt the government's questions. So what we try to do is put the information in to circumvent the request for evidence. But in many instances, a request for evidence could come. And again, I don't want to say that it comes because something wrong has been done. Oftentimes, the request for evidence is promulgated because the government is seeking to clarify some piece of information. Now, there are a certain number of subject matter that are the target of the RFEs. The first one has to do with whether or not the position is professional in nature. And so obviously there's a very discrete way in which we're able to argue that a position is professional in nature. We obviously turn to the fact that a professional level salary is being assigned to that job. We also look at whether or not the Dictionary of Occupational Titles or the Occupational Outlook Handbook or the ONET refer to that position as being one that is professional. In other words, that it has an SVP or specific vocational preparation code that is deemed to be professional in nature. Another target of the RFE might be for the organization that submitted the H-1B to prove that there's enough work in the organization, enough professional level work within the organization to allow an individual to be able to do that work. So oftentimes for very small companies or startup organizations, an argument has to be made that there is enough professional level work for that individual to be able to take that work. So oftentimes when an H-1B is submitted by one of these small organizations, it has to do with work that is contingent in nature, and that if the individual is granted the H-1B, they will be able to take on the professional level work that presently is being undertaken by other individuals who may be in a position of outsourcing for the company. And there are a couple of other reasons why an RFE might be issued, but those are generally the ones that we see. If you have any further questions with regard to RFEs or H-1Bs, please feel free to contact any of our business immigration lawyers here at the NPZ Law Group. Our website is here on the screen. You can also feel free to give us a call. Thanks very much for being with me today, and we look forward to being able to assist you.